Senator Raffoul.
Mr. Vice President, thank you so much for the opportunity to speak. It's always a real honor to be here and to contribute to this debate. The debate today is on the anti-gang legislation, and as always, I strive to be objective in my feedback and technical, constructive in offering solutions and amendments where I see potential risks, and concise to be able to be respectful of everyone's attention and time spans. My contribution will be in 5 parts. One, what the bill is about, and that is particularly what the bill is supposed to be about, what the bill actually contains, and then what changes this bill proposes from the existing legislation. I thought that in particular was a bit ambiguous in our last sitting on the debate. The second part that I want to discuss briefly is a recap of what went before. We sat on this topic 2 weeks ago, and I want to just briefly recap for the viewing public that can't watch 10 or 14 or 12 hours of YouTube video, what I thought were the main points that were highlighted there in terms of the data on gangs, as well as the principles of this debate that were mentioned that day. Third, I want to identify what I see as the advantages of this bill, the risks, and mitigation strategies and amendments. Fourth, I want to answer the question, does this bill today actually address the problem of criminality? And fifth, I would like to conclude with, do I support or do I not support this bill? So first, going into what the bill today is about, it's supposed to be about reducing crime and addressing security of the population. There's actually some very critical things it includes, which is why it's a 3/5 majority that requires this vote, because there's a possibility that it infringes upon property rights and human rights. There are 3 distinct things that this bill contains. First, it makes it an offense to be affiliated with a gang or to be a gang member. Second, it enhances the powers of the police to be able to enable them to search private property without a warrant. And third, it allows additional powers for detainment. How this is different from the existing legislation is this. Currently, if a police officer wants to search a property, they need to have a warrant for search, except for the Firearms Act. Under the Firearms Act, a police officer does not need a warrant to search your property if they believe that there's a firearm in your possession. In terms of arrests, currently a warrant is not needed for an arrest. A police officer can arrest you if they witness you in the committing of a crime, for example, a robbery or a traffic violation, or if they believe that you have committed a crime or are about to commit a crime. And thirdly, when it comes to detention, currently under the existing law, police can detain a citizen for up to 48 hours without a charge. after 48 hours, they must charge you. Otherwise, otherwise the citizen that's detained can sue the state for illegal detention. And what this bill proposes to do is to change it so that for offences that are listed under this act, i.e. being affiliated with a gang, are now able to be detained for up to 72 hours without a charge being laid. After that expiration of the 72 hours, then it is possible that police can apply for an extension to detain you for up to 14 days. For all other offences, it's not possible to apply for an extension. What I found particularly interesting in the last debate was that there was consensus among all parties and all individuals that spoke. The consensus was that there needs to be more preventative action on crime fighting, more focus on youth and education. I found it particularly interesting that there was consensus on the need to strengthen the police service and the consensus on a lack of effectiveness coming from the police service when it comes to crime detection and being able to enforce crime-fighting mechanisms in a speedy and expedient service in service of the population. I found the data was particularly interesting. The Honourable Minister of Labour noted the study from CATS showing that in a survey of gang members in Trinidad and Tobago, of those surveyed, 40% said that they joined for the sense of belonging, 30% for the sense of protection. Only 8% of gang members joined because of economic benefit or perceived economic benefit. So 70% or more joined for the sense of belonging and protection and not necessarily for the sake of economic benefit. What I also found quite interesting was the repeated points by many persons that we already have legislation that makes certain offences criminal offences. So is there need for additional legislation, or is it the issue more about implementing existing legislation? And where is this balance? Do we need to have more legislation? Is this bill relevant, or is this just a Band-Aid to cover a problem that's not really being addressed for some reason in our society? One possible advantage that I saw was this element of risk sharing, in the sense of by being part of a gang, it's now illegal. Well, the bill proposes that it would be an offence to now be illegal to associate with other persons who are gang members, who are involved in criminal activity. And interestingly, this is an element of risk sharing in the sense that it forces you to then mitigate your risk and screen your friends, screen your colleagues, and pull them up if they are possibly tempted to engage in criminal activity. In economics, there's the Grameen Bank, which is a risk-sharing mechanism and has done fascinating work. The founder of it won the Nobel Peace Prize. And it uses risk-sharing to mitigate errant loan behavior. So instead of taking out an individual loan, you take out a loan with 4 or 5 colleagues. And everyone supports each other and monitors each other. So there's this risk-sharing within it, and it's been extremely successful. Now, this is kind of analogous in the sense that it forces you as a citizen to support and encourage those colleagues around you, except this is not financial behavior. This is potential areas of criminality. So it's interesting, but I don't think that that advantage or possible advantage is empirically proven, and I don't think that the same set of decision-making behaviors that go into loan behaviors would be the same that would go into criminality behaviors. In terms of risks, there are several that I see as being quite grave. First, there's a potential for abuse of power by the police, in particular in the searching process and detention process. Second, it puts police officers at risk because now there's nothing to guarantee that, that they have done proper records, and anyone in the population that has been detained because of this bill can just say that, oh, there was police brutality, that policeman had something against me. This bill would remove the protection of having a judicial officer oversee the process and issue a warrant. And that not only puts the population at risk, it also puts the police officer at risk, because anyone can claim that there was subjectivity in his decision. Third, there's going to be a high risk of cases being dismissed in the courts because of potential allegations. Fourth, and this is something that Senator Richards raised in the SSA debate about 2 years ago, that when there's injustice perpetrated by the state, there's then a sense of discord by citizens against the state, and the sense of animosity and mistrust. And that can lead to massive social unrest and a sense of injustice and a sense of diminished well-being, that we're not in a state of justice and equality. We're in a state of fair subjectivity and potential for abuse of power. Given those risks, I always like to suggest amendments and mitigation strategies. I found that the submission by the Law Association was extremely technical and very, very useful. And I think that the amendments that they suggested are worth quoting here. In terms of the definition of a gang, there was 2 problems that they identified. One, that it's a circular definition. So we define in this draft gang and gang-related activity in a circular way. The definition of gang is correlated with the definition of gang-related activity and vice versa. So if it's challenged in the courts, it's likely to be dismissed. So what we can suggest is this: amending it by excluding all gang-related offences from the first schedule of the bill. The second problem with this definition of gang and gang-related activity is that there isn't a need to define gang-related activity as being directed by a gang leader or gang member. Just the offence of gang-related activity should be sufficient without saying who it's directed by. So what we can do is, in the definition of gang-related activity, we can exclude the last sentence, which is the last concluding phrase, which is, quote, which a gang ... requests. The third amendment deals with the issue of breaches of the Constitution, specifically strict liability. And this is that the offences that are listed do not require that the persons charged with the offences knew that there was criminal activity happening. So a person that is young, that might be joining a gang for a sense of belonging or a sense of protection, might not have any idea that there's a sense that there is criminal activity happening, because the way that the strict liability is defined in the legislation means that persons do not have to have knowledge that there's criminal activity happening in order to be accused of being in a gang. The offence itself is being in a gang and not necessarily actually having committed any criminal activity or even having any knowledge of. So the risk is that we can have young persons that can be penalised to 25 years maximum in jail for not having committed a crime and not having any knowledge that a crime was being committed. So the recommendation for the amendment is that we define the offences specifically in a way to make knowledge of the criminal activity of the gang an element of the offence. The fourth amendment has to do with the search warrant, and this is section 52. The problem here is the way the legislation is phrased. It requires that a police officer can request a search warrant based on quote-unquote reasonable cause. Now, what this means is that it's basically subjective, up to the police officer to believe that there is reason to arrest, to believe that this person is in a gang, or that this house, this property that he is applying for a warrant to search, it hosts a gang member. So this interpretation would imply that the police officer only has to swear that he believes that there is something to search in that property and does not require any objective evidence or the magistrate to give his opinion and to give his reasonable belief. So in practice, it is subjective to the mind of the police officer and doesn't have enough oversight mechanisms. So specifically, the amendment I would suggest would be to reword this part to make it such that the magistrate must also be satisfied that there's reasonable cause to believe that the person may be found in the dwelling home. And just to point out, this is actually the process that we use in section 16.5, which is where an application is made to a judge for a detention order. So in 16.5, the judge must be satisfied that there's reasonable grounds for the matters listed for the detention order, but this is not what we currently have worded in section 15.2 for the search warrant. The fifth amendment I have is on the detention. Currently, section 16.1 allows for any police officer to detain a person for 3 days without a warrant based on the basis of reasonable suspicion. So there's two things about this that are unclear and ambiguous. One is that the reasonable suspicion is a lower standard in terms of wording than reasonable cause. So reasonable suspicion is related to the power to detain, whereas reasonable cause is related to the power to arrest. So there's no reason why the higher standard is required for an arrest, but the lower standard, i.e. the reasonable suspicion, is required to detain someone, a citizen of Trinidad and Tobago, for 3 days. The second problem with this wording is that the justification to detain someone is itself unclear. So currently, if someone is arrested for murder, they must be brought before a judge right away under other legislation. But under the proposed anti-gang legislation that we're dealing with today, someone does not have to be brought before a judicial officer. So for murder, they do, but for belonging to a gang, you don't. And that can lead to an abuse of private citizens' rights to be allowed to be detained for such a significant amount of time without having the presence of a judicial officer to be that oversight mechanism. So the recommendation, the amendment that I would suggest today would be to stipulate that a detention must be brought before a judicial officer. The sixth amendment I'd like to suggest is about the application for detention order. Currently, the way that it's worded in the legislation, it does not require a police officer to present an evidence on oath. This is section 16.4 and 5. The recommendation that I suggest is that we make the application for the detention order so that the application to the judge by the police officer is supported by evidence on oath from the police officer and not just on his belief. So to be specific, we would be amending it so that it would be based on an oath of the police officer. Seventh, the current wording doesn't allow the detainee to apply to the judge for a discharge. So if someone is attempted to be detained for an additional 14 days, which as Senator Crease pointed out is 3 plus 14, which is 17 days, which is a substantial amount of time. The way that it's worded currently means that the judicial officer and the police officer can have a discussion absent from the person being detained. This is ex parte. So the person being detained does not have the ability to appeal to the judicial officer and say, this is false, this declaration. So this would make, if we amend it, this section would be such that at least the person who is attempted to be detained can apply for, forgive me, my redress, as Senator Richards is pointing out, to apply for discharge for the detention order. I just want to make sure that wording was correct. So it would be allowing the detainee to apply for discharge of the detention order. eighth and final recommendation on this bill today, the Section 16.3 deals with the custody record, and this is required to record the grounds on which someone is being detained. It's within the legislation that a police officer has to have a custody record recording why they're detaining someone, what is the basis. And it's usually either recorded in pocket diaries or in the station record. Pocket diaries, unfortunately, are not always supplied to police officers, so they don't have those at hand on a consistent basis, whereas the station diary is usually always available. So if we can amend this bill to mandate that the custody record be recorded in the station diary as opposed to the pocket diary, then that would be much more likely to have a higher rate of implementation, because that's always an accessible means of recording. So that's the third section of my contribution, which is dealing with what specific amendments would I suggest to address the risks in the bill today. What I wanted to do in my fourth section was to address the issue of, is this bill addressing the issue of crime or not? There seems to be consensus, in my perspective, that the low detection rate has to deal more with the ineffectiveness or purported ineffectiveness of the police service rather than just the existence of gangs. So what can be done with the police service? I really appreciated the contribution of Senator the Honourable Clarence Rambarat in his last contribution on this debate. I found that he was extremely straightforward about the problems within the police service and the fact that the autonomy of the police service is an issue. What can we as a parliament do given autonomy? This is a problem that I think is existent across many different areas of our public sector system. The fact that autonomy sometimes limits what you can actually do and what you can't do. There are certain things that could be done that I would like to suggest. Of course, there's always constitutional reform, but absent from that, there are other options. The Ministry of National Security can issue policy directives to the police service such that police officers might be mandated to undergo polygraph tests, which is lie detector tests, as a condition for continued employment. That can potentially weed out persons who might have committed crimes in the past, and that might be proven by lie detector tests. The training academy currently in the police service is only a few months. The suggestion is that we make it the Ministry of National Security makes it a 3 to 4 year training program to really improve the quality of the skill set of the police service, as well as the respect of the population for the police service and what they do. Changing the promotional system so that it is more balanced. Currently, it's more heavily weighted towards degrees rather than experience. So changing that weighting system for promotions within the police service so that it's more heavily weighted to experience. Changing the baseline recruitment of police service officers to a higher standard. Currently, I think it's only 5 O-levels are required. We can also update the departmental and standing orders of the police service, specifically to include CCTV footage. Currently, body cameras are already in the departmental orders of the police service, but there are only 60 of these body cameras in existence. Strengthening oversight mechanisms within the police service. Currently, there are 2 bodies of internal oversight. There's the PSB and the PCD. The PSB is the Professional Standards Bureau. It deals with breaches of criminal matters, whereas the other one, the PCD, is civil matters. So PSB, Professional Standards Bureau, deals with breaches of criminal matters. If there's an internal investigation and an officer is found to be in breach of the standards, then the issue would be forwarded to the DPP's office. And then the DPP's office would forward it back to the PCB to lay a charge on the officer. The other division that deals with internal audits of the police service is PCD. PCD is the Police Complaints Division, and it deals with breaches of civil matters. So if there is an internal investigation and an officer is found in breach of a civil matter, then that issue would be forwarded to the Commissioner of Police. Now, externally, there's the PCA, the Police Complaints Authority. One suggestion is that there's a duplication of efforts between the PCA and the PCD, PCD being the Police Complaints Division. But since the PCA has greater independence, the PCA should replace the PCD. Subsequent to that, the PCA, the Police Complaints Authority, should also be strengthened to have the ability to have prosecutional powers alongside the DPP. I'd like to also echo what Senator Creese said about a rehabilitative and restorative approach within our justice system as opposed to just a punitive approach when it comes to what we can do to prevent current inmates from propagating the cycle of violence. And in terms of preventative approaches, I really respect everyone's contribution on what they thought could be done in terms of different training programs, different educational initiatives, sports programs, and whatnot. There are several NGOs and private sector organizations already working in trauma therapy initiatives in Trinidad and Tobago, which have been doing phenomenal work. There's this link between trauma and criminality, and I think that we need to really strengthen our ability to address trauma in our education system as well as in our healthcare system. And there are multiple different methodologies and modalities that can be used for this. Probably the best known one is CBT, cognitive behavioral therapy, and it's a talk-based therapy to help students and young adults and all ages really to be able to process their trauma in a way to help them to prevent that trauma from causing cognitive imbalances or physiological or criminal behavior in the future. There's also things like art therapy and play therapy. There's yoga therapy. I'm very proud to be a yoga therapist. There's yoga nidra is the particular aspect of yoga therapy that's really all about neuroplasticity, which is about regenerating parts of the brain and being able to help individuals process past trauma. There's also animal therapy. Hippotherapy happens on the North Coast. There's a program sponsored by the Ministry of Health dealing with hippotherapy, which is horse-based therapy, techniques to help autistic and special needs children. There's craniosacral therapy, there's body talk and EFT. EFT is also similar to body talk. It's based on acupressure and acupuncture points. And a combination of Chinese medicine as well as acupressure. There are different healing modalities, and I would like to see more of these adopted within our healthcare system and education system. So, in conclusion, do I think the bill today really addresses the issue of crime and gangs? I think it introduces more risks than advantages. I don't think it really addresses the root cause of crime and violence, and I don't think it's really going to solve any of the problems of gang violence in Trinidad. I think it allows too much subjectivity within the search warrants process and the detention process. And the most important thing for me to emphasize here is that we already have existing legislation on criminal matters. So there's nothing new at all in this legislation that I think is actually going to address criminal behavior. The existing legislation, in my mind, and I think from what everyone else has contributed and said in their deliveries, the existing legislation is not being implemented properly. So the way I see it, this legislation is just a Band-Aid. It's just saying something needs to be done. We can't actually address the root of the problem. So, this is okay. But I don't think that it's actually going to address or solve any problems. We already have legislation that's not being implemented. And here what we're doing is we're addressing legislation that unfortunately allows potential for abuse of power. There are the amendments I suggest, and those would reduce the potential for abuse of power. I will base my vote at the end depending on if those amendments pass or not. I always am here in a spirit of being open-minded and listening to everyone. I don't like to come and say, well, I'm voting yes or no, and then having a fixed mindset. I like to hear what everyone says and try and achieve some consensus and be open-minded. As of now, I don't think we need this legislation at all. I don't think it supports our country in any way. I think it's more of a deterrent and introduces too much potential for abuse of power into our justice system. So, Mr. Vice President, I thank you for the opportunity to speak. I appreciate your time. Colleagues, I thank you for your attention.
Sophia Chote.
Thank you, Mr. Vice President, for the opportunity to speak on the proposed Anti-Gang Act of 2018. Perhaps I should indicate that I took the liberty of writing to the Honorable Attorney General with some of the amendments which I would like to see placed into this piece of legislation. And he has those in writing, so I don't intend to go into too much detail with respect to all of them. The good thing about being an independent senator is that we do not caucus, and we do not know what we are going to say as individuals when we come to speak before this Honorable Senate. And I think, listening to my colleagues, I realize that many views are held about this piece of proposed legislation, and I do not share all of those views. I may share some, but not all. If I may try to place this in context, this piece of legislation is not new. It bears a strong similarity to the earlier Anti-Gang Act, which lapsed because it contained a sunset clause. And considerable work had gone into the drafting of that piece of legislation, both by the government then and the opposition, through a joint select committee, which had heard the views of stakeholders and so on, and made recommendations for the proposals to that act. So what we have here is a piece of legislation, with all due respect, that I do not think should cause us too much trouble, because it has been enacted in similar form before. That is not to say that I agree with all of the changes which are to be found in the current draft before the Senate. I think having anti-gang legislation in modern society is a necessity. I don't think it's a choice. Any society where crime is high, you have to deal with the problem of gangs. With respect to how gangs are defined, I'm a little disappointed to see that the definition has not grown from the definition of the earlier legislation. And the reason for that circularity of wording was that at that time, people were now drafting gang legislation all over the world, including the US, and including the state of Arizona, which I think consistently has had the highest crime level in the United States for many, many years. So the time has come for us to look at gang legislation outside of the context of street gangs, because street gangs in many respects are their own worst enemy. They kill each other off. They live in locked conditions of poverty and abuse, generally speaking, most of the money made by gang leaders doesn't trickle down to the people below him. It's a steep hierarchical structure, and vulnerable persons living within that environment who are not involved in gang activity certainly suffer tremendously. And if you've spoken to any of the persons, or if you've walked in gang territory, as I have, all over Trinidad and Tobago, you would appreciate that their lives are dictated by when the gang leader permits people to leave the area. So if you have a job which requires you to get there for 7, and the circumstances are such that you cannot be on the road without being shot before 8, then you have a problem. You cannot walk the road after a certain period of time. When you are inside, you stay inside, and sometimes you can't keep standing inside because a bullet might come through your window and get you, as has happened before. Police officers have a very difficult time dealing with this kind of activity in the current situation. And we will only have to remember the article in the newspaper which spoke about a group of police officers who went to a gang area and could not get out because 2 gangs were shooting at each other. And they had to be rescued by other officers and personnel from this area. So we absolutely need to have anti-gang legislation. But let us not look at this in an us against them way. I think that would be absolutely wrong. It would point a finger at the poor black and brown men, essentially, of this country, and give an indication that they are the only gang people we need to worry about. That is not so. Let us remember that there are gangs which do different things. And one gang may do many things. Depends on your size, your structure, who your friends are, who are your business partners. And I have made some suggestions for the proposed amendment of the first schedule in that regard to include, for example, the offenses of manslaughter, causing grievous bodily harm, offenses under the Prevention of Corruption Act, misbehavior in public office, the offenses under the sexual of course, yes.
I'm so sorry to interrupt your and involuntary in the various circumstances of manslaughter, because it's something that I'm trying to get right before we come to committee. Thank you.
Certainly, no problem. If you don't mind, I'll deal with that at the end, because I'm just listing. In the Sexual Offences Act, we have offences which deal with keeping of brothels and prostitution and so on. And that's tied in with human trafficking, or trafficking in persons, as our legislation calls it, which is also not included here, and which I think we ought to include. Because we want to make sure that this piece of legislation can apply to gangs no matter how they morph or what they morph into. You might start off with a gang dealing in drugs and guns, and the gang may move up the ladder and start dealing in money-related fraudulent offenses, for example. So we need to be able to have the foresight in this legislation to appreciate that the criminal environment changes, just as any other kind of environment. So in that regard, I would also like to have, if possible, included in that first schedule, other offenses from the Sexual Offences Act, which you find out about in gang life. For example, Section 12, which talks about sexual intercourse with a mentally subnormal person. Section 23, which talks about living on the earnings of prostitution. We have the Hijacking Act to take into account, because gangs may be related to that kind of activity. I know that we have the anti-terrorism legislation coming before us, but from what I believe, that may be some months in advance, and we can do something through this piece of legislation to close that loophole. I think we need to take into account as well the Taking of Hostages Act, Section 24 of the Offenses Against a Person Act, certain offenses under the Children Act. For example, Sections 14, 15, and 21, which talk about child prostitution. Section 37, which talks about using a child to sell or deliver dangerous drugs. There is also another section, which I don't seem to have written down, but it is a part of the legislation that deals with pornography. And all of that is related and tied in to the abuse of vulnerable persons by gangs at all strata of society. Because there may be gangs who are bringing in not only people from the South American continent, but there may be gangs who are bringing in some of those people we see from Bulgaria and Eastern Europe. And I don't see why we should create a piece of legislation that is not capable of applying across the board to any gang, regardless of where they locate themselves, whether in or out of the country, whether their members change, or whether they do high-level business or low-level business. I think we have a responsibility to the citizens of this country to ensure that this legislation can be used for the prosecution of any person operating in a gang. Otherwise, we will have enacted a piece of legislation that only deals with street gangs. And that's not good enough. Now, for that reason, having said all of that, I can get to the point where I respectfully suggest that the definition of gang suggested by Senator Richards should be adopted, because that's an example of more modern legislation where you talk about gangs in the context of being criminal organizations to do different things. And you get away from the circularity in the wording, which may cause trouble further down the road in terms of interpretation. Now, if I may just continue, I'm respectfully suggesting that 6.1 be amended, 6.1c, to include the words professes to be a gang leader or a gang member, to include the words for himself or any other person, to the benefit of for himself or any other person. 6.4, I'm suggesting should be kept in line with what comes earlier, and all those positions referred to there should be dealt with as law enforcement authority. Section 6.5 I have some problems with because it deals with two different kinds of mens rea in the criminal law within one section, unlawfully and maliciously, which means one thing, and with intent, which means a different thing entirely. I'm respectfully suggesting that that should be corrected. Section 7, I was wondering about this section because our Accessories and Abettors Act already criminalizes aiding and abetting, counseling, procuring, and so on. So I think that may already be covered. I don't know if this section is required. I have made suggestions that the section that deals with harbors or conceals, harbors, should be joined with concealing as an alternative, that the drafting should be done so that you commit an offense if you are harboring or concealing a gang leader or a gang member, and there should be a separate offense for concealing gang-related activity or items which you obtain through gang-related activity. Section 15.3, I am respectfully in some difficulty with respect to this, because it seems to be saying that the police can go into anybody's premises, whether it's a church, school, nightclub, private members' club, other people's homes, and that kind of thing. And that is a very draconian step to take. So it seems to me that it's not going to be the end of the world if a police officer is required to go before a magistrate and justify why he needs to do that. Now, and this is only because the police officer has reason to believe that that person is physically present. Well, could you not surround the place and arrest the man when he comes out, as happens now, without infringing on the rights of the hundreds or so people who might be within the establishment, the business establishment, at the time that the gang leader or gang member is there? So I'm just saying that it seems to be a bit of a heavy hand. I have no problem, because this kind of legislation is necessarily heavy-handed, and we absolutely need this kind of legislation to deal with certain kinds of criminal activity. But we also have to consider that when we want to extract persons who have committed offenses under this act, that we do not do so and breach the constitutional rights of citizens who may innocently be there at the restaurant having a night out or at the nightclub and that kind of thing. So I would respectfully ask that consideration be given to the inclusion of the requirement for a warrant for such a search. In addition, I see there's no reference for it in this piece of legislation to searches of maritime vessels and aircraft. I think that's absolutely necessary. I mean, the fact that drugs were allegedly found in a vehicle on the Cabo Star, I think only a few days ago, is an indication that we need to have that power to search vessels. I know the power already exists under the Dangerous Drugs Act, but the fact of the matter is, if we want to use this act because the drugs being trafficked are being trafficked by a gang, then we need to have that kind of inclusion in the words of the act so that the stiffer penalty may be arrived at. With respect to section 16.3c, I know that it is proposed that a record be made in the station diary of the detention of the person in question. I'm respectfully suggesting that it remain in the act, because the standing orders, they are not primary legislation. They are just standing orders by which the police officers regulate themselves. And we want to have accountability. Now, this protects the police officer as much as it protects the accused person, because many accused persons come afterwards and make allegations that X, Y, and Z may have happened. And if the police officer has not made proper records at the time to protect himself, then he finds himself being rather hard-pressed, if the matter reaches a courtroom, to say that, yes, I can show that I did X, Y, and Z because a record was kept at the time. So I think having a record, perhaps in the station diary, and the earlier piece of legislation had also included giving a copy of the record to the person being kept in detention. I think that is necessary because if the person is entitled to go and challenge his detention in a court, then you want him to have equality of arms in that case. So I'm respectfully suggesting that a copy be given to the person. Section 17. Now, oh dear, this section creates a problem. The Proceeds of Crime Act has been interpreted by some magistrates to say that if you are robbed of your handbag and your handbag contains money, that constitutes the proceeds of crime. So it means that the police officer can seize that money, keep it, take it to court, and at the end of the day, that money could be forfeited to the state. Now, that kind of interpretation, with all due respect, not only is it wrong, but we want to make sure that we don't create legislation which allows for that kind of uncertainty and, with all due respect, injustice. So I am respectfully suggesting that Section 17 be amended to provide for items of value or money to be returned to victims of crime. Not every gang-related activity results in only gang members or gang leaders having cash and having items. It may simply be easy to find who is the legitimate owner and to give restitution to that person. But all the section provides for is the right to be heard. It doesn't provide for restitution. So I ask that the victims of certain kinds of crimes, because we do have robberies referred to in the first schedule as applying to this particular act, so I ask that that be considered for the victims of certain kinds of crimes. I totally agree with Senator Ramkissoon on the tipping off point, and I say that because it was brought to my attention in an earlier exercise that sometimes police officers are going out on investigations and they have to ask their fellow officers to hand over their mobile phones. And even that does not avoid the risk of the gang members and gang leaders being tipped off about the police raid. Some officers who may have gone to school with the gang members or who may be related to the gang members in question often drop out of the exercise, the police exercise at the time, because they can then stay back and do the tipping off. You have had incidents where police officers who have been trained, and I'm not talking about now, I think the public needs to understand that we are not novices in training our police officers in dealing with gangs, but I will come back to that in a little while. We have had instances where you have joint operations with the defense force. Well, your police officer in charge of the operations is not in charge of the defense force officers except for the purposes that they are there. So he can't tell them, okay, give over your cell phones. And I think we have to appreciate, it takes me to the logical point, that we have to appreciate that the proliferation of gangs in this country could not have happened without the clear infiltration of our protective and investigative services by criminal gangs. So the links are there. And don't glorify, I totally agree with Senator Crease, don't glorify Mr. Burrows. If you read enough about it, you would be embarrassed by such glorification. So tipping off, I think, should be criminalized, and there should be a penalty for it. I also do think that gang members or gang leaders or persons connected to gangs who are found to have committed offenses under this piece of legislation and who are members of the protective services should receive a stiffer penalty than the citizen who is a gang member or a gang leader. Because the person who is a police officer or a soldier or a Coast Guard officer who is performing the duties of law enforcement and using that as a cover to commit offenses or gang-related offenses or to protect gangs, in my view, deserves stiffer punishment than the person who is the member of a street gang. Now, I have a lot of sympathy with what Senator Creese suggested about campaign financing and so on, but that is a totally different piece of legislation from the way I see it. But I do think that in this piece of legislation, we can put in things to say that if you are convicted of an offense under this legislation, you will be precluded from state housing, state leasing of land or accommodation, state business. Whether it is, well, perhaps I should not use these examples. I will simply say, for example, if you are in construction and you have contracts with any state entity and you are convicted of an offense under this legislation, you should immediately have that contract terminated. And the person within the state entity who entered into that contract with you, if that person ought to have reasonably known that you or your company was involved in gang activity, then the public official should also face a criminal charge. That is not included here. You need two hands to clap, and I think to some extent the legislation doesn't go quite as far as it needs to. So I support this legislation. I don't see what is the fear about it, because it is legislation which countries, all civilized countries where the rule of law operates, they have had to enact. We are not unique in that respect. Let us not become too afraid. Yes, gang members and gang numbers have gone up, but there have been changes in our society which perhaps account for that. We've had people coming in through our borders because their countries are in crisis. I'm not assuming that everyone who comes in is law-abiding. And those people may already have, some of those may already have had criminal links with the gangs here, at any level. So let us not assume that it is because things within this country are spiraling out of control that we have this sudden proliferation of gangs. If you think about it logically, you would anticipate that in this kind of changing environment, that you would see that phenomenon arise. So it makes it even more important for us to have very clear legislation to ensure that regardless of whether you're a citizen of this country, but if you come here and you engage in gang-related activity, you will be dealt with according to our law. And I think that is an important message to be sent to all. Whether it is the people who are renting roulette machines to rum shops all over the place, and bars, and that kind of thing, and money laundering as a result, because they hold huge amounts of cash. Let us ensure that those persons are also held liable under this legislation. So I'm respectfully suggesting that these amendments should be made to what we have before us. I know that I got a sort of unofficial version of proposal amendments already, so I've tried to take those on board in my contribution. With respect to the Honorable Attorney General's question, yes, there is a difference between involuntary and voluntary manslaughter, but that does not need to worry you at this stage. Through you, Mr. Vice President, I beg your pardon, because once you have manslaughter, it will be for the person recommending the charge to determine what evidence is required to prove it. And the person looking at the elements of the offense, whether it's the office of the DPP or whoever it is, such a person will know what is required to be proved. For example, you are not charged, if a charge is laid against you for manslaughter, you are not charged with voluntary manslaughter or involuntary manslaughter. The information or the indictment simply says manslaughter. And the particulars of the information or the indictment will say, well, what it is you did that the state is saying you were responsible for any particular kind of manslaughter. I hope that that has cleared it up. So I think this legislation is absolutely necessary. It is not new. It has been vetted by this Parliament and the Parliament before by both sides. We need to have this legislation. I think that if rights can be shown to be protected under this legislation, and the legislation is all-embracing, and not only street gangs are the subject of it, then I don't see why we need a sunset clause. Now, I know that is an unpopular view, but the fact of the matter is gang activity is here to stay. It is not going to go away. So let us make sure that what we have or what we create here today is clear, precise legislation, which is not going to weigh down any court as people debate what the interpretation should be. Let us make sure that we don't make the same mistake as before and have premature charges laid, which meant that the last piece of legislation was considered to be too hot to touch. So there were very few prosecutions after that whole incident. That was the fallout of it. The officers who I knew were highly trained at the time, all they needed help with was to learn how to put together the material for a prosecutor so that the case could be taken to court. I am so sorry to see one of the best officers who I had worked with at the time, he is escorting prisoners in one of the magistrates' courts. So I don't intend to go into a whole diatribe about the police service and what they could do right and what they're not doing right today and this kind of thing. That's not, in my respectful view, we're looking at the legislation. We can't change the world with a piece of legislation. But I certainly do think that we should keep an eye on problems like that to ensure that this piece of legislation works more effectively than the last piece of legislation did. So with these few words, I thank you, Mr. Vice President.
Senator Mark. Thank you, Mr. Vice President. Mr. Vice President, I rise to make my contribution to this very important piece of legislation dealing with gangs in Trinidad and Tobago. Gangs that have mushroomed from a few to close to 300 at last count, or approximately around that number, and from a couple hundred to close to 3,000 as we speak, and mounting and growing. But we would not have been able to debate this measure today if it was not for the extraordinary intervention of this alternative government led by the extraordinary leadership of the Honorable Kamla Prasad Visesa. And you know, Mr. Vice President, as it is said, extraordinary times require extraordinary leadership. And Trinidad and Tobago must be comforted with the kind of leadership that we have been able to demonstrate. Demonstrate, Mr. Vice President, as it relates to this society via the advancement of our leader to the levels that we are all familiar with. And Mr. Vice President, we know that if you have weak leadership, you're going to manifest that in what we are all witnessing in Trinidad and Tobago today. Total confusion and chaos under the leadership of the PNM. But what is very important to pay attention to is that leadership is not about showmanship. And I can give you the assurance that if the Minister of Foreign and CARICOM Affairs was a member of the Kamla Prasad Visesa's government, he would now have been history. I can also give you the assurance that if the Minister of National Security, who is now holed up in a New York court, was a member of the Kamla Prasad Visesa administration, he too would have been history.
46-1, as well as Standing Order 46-4, Mr. Vice President. And 6, 48-6, 46-6.
46-1 and 46.
4 and 6, 46-1, 46-4, 46-6.
Honorable Attorney General, I overrule that point of order.
So, Mr. Vice President, what I'm saying is that we need strong leadership to take decisive action so that the ship of state can be steered properly and in a very even keel manner. I want to also say, Mr. Vice President, for many of our colleagues who are here, that under the leadership of Kamla Prasad Visesa, in the People's Partnership, Dr. Lester Henry would have been history.
Mr. Vice President, not only relevance, but the improper motives that continuously fall from my friend under subsection 6 as well.
Mr. Vice President,
Senator Mark, at this point in your contribution, I would ask you to get to the bill in front of us in that, in relation to the point of order raised at this point.
All right, I shall return to history later with your guidance. Mr. Vice President, what is the reality facing TNT as we speak today? You know what is the reality, Mr. Vice President? The government has brought legislation which, in principle, we have said on the opposition benches that we will support. But we would like the legislation to be tweaked so that, for instance, the rights of citizens and the avoidance of liabilities to the state because of wrongful arrests can be avoided, Mr. Vice President. Mr. Vice President, I would like to say that when we are dealing with the issue of strategies to address gangs, we have to look at three essential strategies that are essential for an understanding of how we address gang activities in our country. We can look at prevention, we can look at intervention, and we can look at suppression. These are the fundamental essential strategies that we can look at when we are examining gang activities. I don't believe that this one-size-fits-all approach that the government has to deal with crime in this country is going to get us very far. The government has taken what is called a draconian and oppressive approach to dealing with criminal gang activities in our country without drilling down in a very analytical way to what could be the basis or the root causes for the emergence of crime, criminality, and gang activity in our country. So that is why, Mr. Vice President, if you look at the policy of this government manifested in this document, in the bill rather, the policy is one of suppression and incarceration and imprisonment and punishment. That is the policy of the government. They believe that's the only way, Mr. Vice President, that public safety can be guaranteed in TNT. Well, what is the evidence, Mr. Vice President? What is the data before us telling us that that approach does not work? That approach has failed. You go Chicago, you go Los Angeles, you go to many American states today, you go to El Salvador and Jamaica, what you have is an explosion of crime in those countries. And Mr. Vice President, they have instituted some of the most criminal and draconian measures to suppress crime in those countries. But what is happening in Jamaica today? Crime is out of control in Jamaica. El Salvador today, you know what they call gangs in El Salvador? They call them terrorists. They have outlawed gangs in El Salvador, Mr. Vice President, and they are now known as terrorists. I do not know if that is where we want to go in Trinidad and Tobago. If, for instance, we cannot control gangs in this country, the next thing we will say is that these gangs are terrorists. We don't know, Mr. Vice President, and we are avoiding the critical issues. So this hardline approach, Mr. Vice President, to gangs will not succeed, and the government is to our, when we analyze this document, this bill rather, properly, Mr. Vice President, you know what we are seeing? We are seeing that the government is imposing a police solution on a social problem. What we have is a social problem in this country. When wealth in this country, 90% of the wealth of this country could be controlled by 2% of the population. When the Gini coefficient of income distribution reveals that there's a 43% Gini coefficient rate in this country, what does that tell you, Mr. Vice President? It tells you that we have a society in which the rich are becoming richer and the poor are becoming poorer. That is what we are talking about. And then instead of bringing policy measures to deal with the socio-economic realities of our country, what do we get from this Raffoul-led administration? More oppressive, repressive, draconian measures to get at who? The ordinary working class man and woman from Laventille, from John, from Sealat, from Belmont, from San Fernando. So you are out to incarcerate, according to the information we have today, Mr. Vice President. There are over close to 4,000 gang members in this country. So what you are going to do? The AG has boasted. He knows every member. He knows all the leaders. He knows where they are. So when this bill passes, are you going to lock up all of these people, Mr. Vice President? But it's the very AG who has told us that it costs this country $25,000 a month to maintain prisoners in this country. He's on record as telling us that. Mr. Vice President, I am saying that more police, more prison, more punishment will not stop gang violence in Trinidad and Tobago. What we need is a more scientific approach, a more science-based approach to public safety in our country. I call on the government to invest more in jobs, invest in jobs, invest in schools, invest in programs for the young people. That is what you have to invest. Otherwise, we will lose the war on gangs in this country. It's only a matter of time if we continue how we are going. Mr. Vice President, when I drill down into this bill later on in my proceedings, I will show you, for instance, the abuse and the discrimination in its application that lies at the heart of these measures, and the potential for innocent people to be incarcerated by the security services is real, Mr. Vice President. Very real. And it's not to say we have a police service here, elements of it, but I would say the majority of the police officers are good. But, Mr. Vice President, let's face the reality. We have a minority, crooked, corrupt, and they will use that power to abuse and misuse and incarcerate ordinary people in this country. We do not have a police state, and we have no intention of giving this government power to create a police state. Mr. Vice President, let me tell you what the literature is saying based on the research. Because if you don't research this thing properly, you come up with the wrong solutions, you know. You can't cut and paste legislation. Gang legislation has failed in Trinidad and Tobago. It has failed. And therefore, what the government is trying to do is we are trying to help the government, is to tweak what they have brought here to make it workable. But, Mr. Vice President, what are some of the socio-economic factors that encourage young people to join gangs? That is what we should be looking at. That is what we should be examining. Not to bring amendments here like the AG and say from 20 years to 25 years, from 10 years to 15 years, and from 15 years to 20 years. It appears, Mr. Vice President, that the language of this government is punitive, is more draconian power, more punishment. That is the only way they know how to solve problems, Mr. Vice President, by incarcerating you, by punishing you. by imprisoning you. That is the solution as far as the government is concerned. Well, Mr. Vice President, let me share with you and my colleagues here, based on the research that I have conducted. In Trinidad and Tobago, in the Caribbean, and internationally, what are some of the factors, particularly socioeconomic factors, that generate young people and encourage them to join gangs? That is where we have to go to understand the solution. Overcrowded living conditions. One factor that leads young people to join gangs. Lack of public space for recreational and sporting activities, another factor. High unemployment and underemployment, another factor, Mr. Vice President. Intra-familiar violence in communities. The proliferation of guns, easy access to drugs and alcohol, and reducing economic and social inequality in communities. These are some of the factors that lead young men and women to become part of gangs. What you have to do is to come up with solutions to deal with those problems, not to come up with solutions to put people in jail. That is not the answer. Incarcerating our young people, Mr. Vice President, is not the answer. That is backward thinking on the part of the PNM. Mr. Vice President, gang membership in this country are associated also with school dropouts. Mr. Vice President, do you know that the Honorable Minister of Education came to this Parliament and told us between 2008 and 2015 or 16, over 12,000 youths between the ages of 12 and 16 dropped out of this education system in our country. Where are they? If you have 12,000 youths dropping out of the school system at the primary school level and at the secondary school level, who would be tracking down these people? That is what we should be focusing on. These young people who are lost in our society. Mr. Vice President, teenage pregnancy and parenthood. That is another major factor, Mr. Vice President, in our country that deals with this question of encouraging young people to join gangs. I call on the government to promote a positive youth agenda in this country. You put a positive youth agenda. Mr. Vice President, you know what this government is doing? Where they have their own priorities. To build a highway in the bush behind God Back for almost $500 million. But you know what's going on? MILAC reduced by $4 million. Civilian Conservation Corps, they cut it by $13 million in last budget. Mentoring program for youth at risk, nothing, it comes to zero. National Youth Service, nothing allocated. Grants for the expansion of the Universal Early Childhood Center, cut down by $2.7 million. Mr. Vice President, in education, UTT, reduced by $7.5 million. National Training Agency by $1 million. White by $9 million. Costard by $20 million. This is what the government is doing. The government, Mr. Vice President, is reducing areas that they ought to be increasing and focusing on, Mr. Vice President.
Vice President, 46-1, 20 minutes in, a clause at least. It's not a general debate.
Mr. Vice President, I understand second reading will be the general principles and merits. We are not in the committee stage.
Not a clause yet.
Yes, Senator Mark, I'm going to ask that you, as you continue with your contribution, to tie it in to the bill that's before us. I understand that the connections that you're trying to make and the points that you're trying to make in relation to gangs and what should be done. I ask that, as you're giving your examples, wrap those up and move on with other points if you have them.
Yeah, well, I have plenty, so I need about 3 hours. I have plenty contribution to make this. Because I've studied this thing, you know. I've studied this in the interest of the poor people in this country. We represent the salt of the earth. When we go into Belmont and into other places, we must tell them why we have posed and we are posing these alternatives and why the government is seeking to put you in jail. We are not about putting you in jail. We are about liberating you. That is what we are about. Mr. Vice President, let me continue, please. Mr. Vice President, I'm continuing, please.
And 53(1)(b.
Yes, I do not know why this bearded
I've raised
man...
3 standing orders.
Okay, Mr. Vice President, I'm going on.
Mr. Vice President, I rise on standing order 46.
You cannot stand while the president is on his legs. Take your seat.
Repeat your standing orders, please.
Mr. Vice President, thank you. 46(1), 46(6), 53(1)(b).
Senator Mark, in relation to the standing orders raised, continue with your contribution and move forward with the points that you're making.
Thank you, sir. Mr. Vice President, I do not know why the AG is jittery. Why is he jittery? Mr. Vice President, we have a situation in which the Attorney General has brought legislation to incarcerate young people. And we are saying we are not in support of that. We are in support of liberating young people.
46(6), 46(4), Mr. Vice President. These are terrible imputations of an improper motive, particularly on my part. And the Honorable Senator is continuously making these statements in an unguarded, cavalier fashion.
I have ruled on the point of orders raised. Understanding the contribution that is being made by the Honourable Member, I've asked him to wrap up that line of thought that he's going forward with, and I'm now allowing him to move forward in relation to his contribution and moving on to other points. Senator Mark, just to restate, 1 second, just to restate, I understand the point that you were making before. You've made that point through the last 20 minutes. I'm asking you to move forward in relation to the bill that's before us.
Yes, I'm guided by you, sir. Mr. Vice President, I want to tell you that, and this is a critical point before I get into some other critical matters before us. Mr. Vice President, would you believe that over the last 3 years, the Rowley-led administration has spent 25...
Senator, just the second time I've heard you actually make that statement. When referring to members of any chamber, please refer to them by the title. So it will be Prime Minister and not Rowley-led government. Thank you.
Minister, we as a government or a country would have collectively allocated over the last 3 years, Mr. Vice President, close to $25 billion to national security. $25 billion to national security. And that is to deal with public safety. That is to deal with, Mr. Vice President, to suppress crime, to deal with crime. But, Mr. Vice President, when you look at the amount of money we have spent and you look at the population of 1.4, that is equivalent to $17.7 million per person. And if you had given each person that a day, it would have been $1.4 million. Madam President, Mr. Vice President, I call on the government to take some of this money and put those monies into preventive programs to help the young people rather than incarcerate them and imprison them. Mr. Vice President, I did some research, again with your leave. The research revealed that a study conducted by a chap called M. Charles Cath and David Chote, entitled Diagnosing Trinidad and Tobago's Gang Problem by the American Society of Criminology. A conference was held in California, Mr. Vice President, back in, I think was 2000, I have the document here. It was back on the 1st of January 2006. And Mr. Vice President, in 2006, what did the evidence reveal at that point in time? It revealed that the number of young youth gangs and gang members in this country during the period of 2000 to 2006 was 95 gangs, with a membership of 1,269 members. What was the composition, Mr. Vice President, of these gangs in our country? 83%, according to this study, Mr. Vice President, I can send a copy to you, sir. This is a study. 83% of the gangs were made up of African youths. 13% were made up of East Indian young people. There were no female-dominated gangs when the study was conducted. About 87% comprised of adults. 2/3 of the gangs were made up of between 6 and 50 members, Mr. Vice President. And 95% of the gang comprised of citizens of the Republic of TNT. This is what the sociological research revealed. And that was between the period 2000 and 2006, Mr. Vice President. I don't know what the figures are today, but this is what the sociological study revealed. It went on to say further, Mr. Vice President, that the number of gangs per station, that is police station district, were as follows. Besso Street, 19 gangs with 385 members. Sawo, 8 gangs with 130 gang members. Sangre Grande, 8 gangs with 90 gang members. St. Joseph, 7 gangs with 5 gang members. Belmont, 6 gangs with 165 members, Mr. Vice President. That is what the data revealed in the period 2000 to 2006, Mr. Vice President. Mr. Vice President, today, as I told you, this number has grown exponentially. We have gone, Mr. Vice President, from just about a few gangs, Mr. Vice President, in this country, to close to, I said, 300 gangs. And it's mounting, Mr. Vice President. And therefore, all we are advancing to the Honorable Attorney General, who is very, very touchy this evening, is ways and means, Mr. Vice President, of trying to get some new focus on this gang culture. The university, Mr. Vice President, did a study in 2011. And in this study of the University of the West Indies, they had a conference entitled Break the Silence, End Child Sexual Abuse. And they talked about the gang culture in our country. And Mr. Vice President, in this study, they revealed, Mr. Vice President, that in Trinidad and Tobago, there were separate or several categories of gangs. They talk about gang, the first category dealt with drugs and guns and money laundering. The second category, they talked about, they were the marginalized people in the communities being neglected by state and state authorities, and they had to come together in order to survive and to gain employment. The question here is that we are putting together legislation, Mr. Vice President, in a one-size-fits-all situation without understanding that the culture, the gang culture and its categorization has to be properly studied. Otherwise, you are going to be targeting young people, innocent people, who may not be involved in drug running, in money laundering, and in other nefarious activities. And this is what this matter I spoke to you about revealed, Mr. Vice President. Mr. Vice President, there is a study also, and it's a court judgment. And I hope the Attorney General would, in fact, pay attention to that particular court judgment that came out sometime in, I think it was 2003, Mr. Vice President. And that particular court judgment, Mr. Vice President, dealt with Marlon Francis McQueen and the Attorney General of Trinidad and Tobago. It was delivered by Justice Peter Rajkumar, and it is dated, it is 8CA 2969 of 2003. And it deals with the whole question about unlawful detention of citizens. And it tells you what you have to do, and if you don't do it right, we will have a lot of state liabilities on our hands. And I think this is a judgment that the Attorney General will do well to study, because it tells you what not to do in terms of seeking to impose draconian measures on the citizens of this country, Mr. Vice President. Mr. Vice President, we have looked at the question of the various provisions that we have in this legislation. And we have seen, Mr. Vice President, where in Clause 4, we talk about law enforcement. And when you look at the definition of Clause 4, I would have thought that the government would have added, apart from the police and the army and the customs, they would have included government ministries and government agencies and identified those agencies. Because you need state intervention. You need social intervention. You need the ministries to be involved in this matter. And this cannot be something that's left to the protective services, Mr. Vice President. You need to get other agencies involved in this particular matter, Mr. Vice President. Mr. Vice President, when you go to Section 6 or Clause 6 of the legislation, it talks about a gang and gang-related activities. It says a person who is a gang leader or a gang member or professes to be a gang leader or a gang member in order to gain a benefit, intimidates other persons, or promote a gang commits an offense. Now, Mr. Vice President, when you said there's this expression to gain a benefit, what does that mean, Mr. Vice President? Again, the doctrine of vagueness is at work here. You cannot bring legislation that is vague and is imprecise. It is unconstitutional to go that route. And there's this concept of the doctrine of vagueness and broadness. And we are seeing in many provisions in the legislation these doctrines at work, Mr. Vice President. And therefore, you have another situation, Mr. Vice President, where you could be incarcerated because you were the wrong place at the wrong time, Mr. Vice President. Mr. Vice President, hear this classic. It is the classic of the century. It is Clause 13. A policeman is you commit a crime. A person commits a crime or an offense if in response to an inquiry from the police officer as to the whereabouts of the gang leader or the gang member, the person does not reveal the whereabouts to the police officer despite knowing where that person is. How is the policeman to tell Mr. Vice President that the gang person who they are interviewing knows about the whereabouts of the gang leader? How is that possible? This is the doctrine of vagueness at work here. And you are giving the police extraordinary powers to innocently incarcerate people. And this is purely subjective. Mr. President, Mr. Vice President, and these are matters that the government would have to take on board.
Senator, you have 5 minutes.
Yes, sir. So, Mr. Vice President, in an effort to tighten the legislation, I am circulating a series of amendments aimed at tightening this legislation. I propose to circulate amendments to Clause 13, 13.1, 13.3, 14.1, Mr. Vice President, 15.2, 15.3, 16, subsection 16.4, and to ensure that the rights of citizens, because we are not a police state, under our watch, I'm talking about the watch of the United National Congress, Trinidad and Tobago will never become a police state. So I want to tell you, Mr. Vice President, that in an effort to ensure that innocent people do not fall through the cracks unnecessarily, we are also proposing 2 new forms and 2 new schedules for this Honorable Senate's consideration. And these matters will be circulated in due course, Mr. Vice President, because as we are saying on this side, we are in support of the legislation. We would like to see the legislation advance, but Mr. Vice President, that legislation can only advance in the interest of all. And I'm sure that the Attorney General would want to ensure that we do everything in our power to ensure that there is no injustice and there is no abuse, Mr. Vice President, of powers given to the security services in this country. So, Mr. Vice President, in closing, I want to say the following. We should avoid legislation that is vague and that is overly broad. What behaviors are we trying to correct or alter must be precise. Do not go with vague and, as I said, overly broad definitions. We need more narrow definitions in order to reduce or curtail police discretion in these matters, Mr. Vice President. And when we are dealing with gang activity, it requires a comprehensive and multifaceted approach to whatever we are doing, Mr. Vice President. If we get it wrong, Mr. Vice President, then gang violence could consume our country at a terrifying speed. And we don't want that. We want to ensure, Mr. Vice President, that we assist in strengthening the legislation. The amendments is going to do exactly that. And we are hoping at the end of the exercise, we will be able to collectively bring good legislation to this country where we promote the state, the state in terms of its protection, and at the same time, you safeguard and balance the rights of the citizens of this country. So we want to balance both the state as well as the rights of the citizen, and therefore the legislation must establish those critical and essential balances, Mr. Vice President. So, Mr. Vice President, I would like to thank you for giving me the opportunity to make these limited few interventions. I hope at the end of the day, we will be able to contribute to the strengthening of the legislation in the interest of the nation. And we hope that the government of Trinidad and Tobago will join us in trying to strengthen the legislation. So at the end of the day, we will pass good laws in a unanimous manner in the interest of the entire population of the Republic of TNT. I wish to thank you for the opportunity.
Senator Prescott.
Thank you very much, Mr. Vice President and my senatorial colleagues. May I permit me a personal observation? I am returning to the Senate in 2018 after some years in the 10th Parliament, and I can't recall being warmly received anyway as I have been received today. It would be imprudent of me to suggest to anyone that they should ask me to come back. But I'm sure this message has been received in the right quarters. Mr. Vice President, I rise to make a contribution to the Anti-Gang Bill 2018, but regrettably, I am handicapped because from what I've just heard from Senator Mark, it appears that there are many amendments proposed on which I will not have the opportunity to comment. And knowing the extent of his wisdom, I anticipate that he will propose amendments that I myself could never have thought of. And therefore, I will not get the opportunity to add to them or seek to modify them. But nonetheless, I am not inclined to come to the Senate and remain silent. So I will make my contribution anyway. I'm very privileged having chosen to await to hear the observations of my colleagues, Senators Raffoul and Chote, because they've given me some guidance on some patterns of thinking that I had. And it will avoid me wasting the Senate's time. I therefore have 4 matters on which I wish to speak. And I hope that the Honorable Attorney General, in his winding up, would take them into account. I hope that at the committee stage, some of what I say might resonate so that they too can be taken into account there. Firstly, it might be good to remind members of this Honorable House of the duties of the police officer, which are set out in the Police Service Act, Chapter 1501. I am a bit handicapped. The text I'm using refers to Section 46, and the one I have at home refers to Section 36. This is the 2015 edition, and because I am uncertain, I will just read the very provision into the record so that Hansard will reflect that I did try. I'm sure somebody will find the correct section. In the text I'm reading, it's 46, Section 46 of Chapter 1501, the Police Service Act. 45. And it says a police officer, B, may arrest, charge, and bring before a summary court a person found committing any offense, rendering him liable to arrest without warrant, or whom he reasonably suspects of having committed any such offense. It tells us, therefore, that the police officer already has great powers where he has reasonable suspicion that an offense has been committed to bring persons before the court. What Section 45B, what that section appears to place the emphasis on, however, is that between the arrest and the bringing of the potential offender before the court, very little time must be allowed to elapse. His duty is, having arrested the person, to charge him and bring him before the court, allow the justices to intervene and the justice system to take preeminence over what happens thereafter. In introducing, as we have, the anti-gang bill, powers, greater powers in the hands of the police, I regret it appears to me that we are taking what may be described as an invidious step of placing even greater power in the hands of the police. Primarily because, and the observations are being heard all around, primarily because, like me, nobody seems to know what to do about crime in this country. I don't think the drafters of the legislation do. I don't think any of my colleagues in here has provided the answer yet. I doubt we will get to it if all we do is introduce legislation of this sort, but it is another effort, and hopefully it works. I, therefore, would want to start my contribution by inviting your attention to what is proposed at Clause 16 of the bill. Now, I have seen the proposed amendments of the Honorable Attorney General. And so I'm looking at the unofficial consolidated version which has been circulated, being mindful of the fact that they are mainly amendments. The first thing, therefore, I wish to raise is this. Is there an understanding, or pardon me, may I put it differently? Do we have a distinction in our minds, and this is really directed at the Honorable Attorney General, between detention and arrest? We have suggested in Clause 16 that a police officer may simply detain, and simply is a really unfortunate choice of word because it is more than simple, it is very, very serious. He may detain a person on the basis that he suspects that this person has committed an offense. And detention, in my way of thinking, until corrected by the Honorable Attorney General, is to be distinguished from an arrest. So that you're coming along the street and there's someone who fits a certain profile, you may, because that profile tells you this person has the potential to, or has already committed some offense, to take such a person to a place and detain the person. There is no need to tell him that he's under arrest. Indeed, that may come much later. There is no need to charge him with an offense. That may come much later. He is being detained. Now, I haven't practiced criminal law for about 30 years, so the chances are I will find out inside this honorable house, and I know there are criminal lawyers here, that this is not the reality. But if a police officer exercising the powers proposed in Clause 16 were to detain me or some other unfortunate, how long, if I may pose this question to you, to the Honorable Attorney General, for how long may he keep me answering questions in the police station or the detention center or wheresoever people are kept before he's required to lay a charge? The Police Service Act says that once he has arrested me, he should charge me. But if he has not arrested me and has merely invited me to remain detained until he satisfies himself that I am either not worthy of his attention or that I should be charged, what is my status really in relation to such a person? Is the well-known writ of habeas corpus directed at detention of this sort? Are attorneys permitted to make an application on behalf of a person who is being detained properly under Clause 16, to have him relieved, returned to his liberty, to have his liberty returned to him? And if so, when? If as we have been told in Clause 16, the police officer may arrest a person who he thinks has committed an offense, the question remains, is there another stage called detention, and which comes first? Let me use a timeline to make my understanding of this clear. And if I am wrong, then that too needs to be taken into account, because it means that there are people out there who do not understand the law, and the law must be very clear to all of us. Otherwise, we may find ourselves losing our liberty without any idea why it has happened, only to find that the law permits such a thing to happen. May I just digress slightly to say, it appears that all that we have really done or are doing with the anti-gang bill today is to be creating powers of detention where none existed before. Nothing else. The police now have the powers. I think in England they had something like that called the sus laws. If he suspects that you are such a person, he holds you. And thereafter, your liberty is at stake. It has been tarnished, your name has been tarnished for a long time to come, and you may well find yourself either imprisoned or returned to your home, but you've now found yourself in the, what is the electronic word for it? in the reservoir of information, of data. The database, the modern word, the database of the cloud, which, yes, we all will find ourselves under the cloud in such a case. My timeline goes like this, sir. Wednesday the 1st of any month, a policeman asks you to come to the station to assist him with some inquiries. A polite inquiry, a polite request. A citizen like me, an upstanding one may say so, and nothing to be afraid of. For how long may he do so? Keep me there so that he may pursue this belief he has that I can be of assistance. I would imagine that the criminal lawyers who have my interests at heart may take a stand, but are unlikely to get that done under 48 hours. And I heard today, yes, Senator Raffoul made the observation that you can be kept for 48 hours. I think it's about correct. But in any event, by the time he gathers up his armory, my criminal attorney that is, to approach the court with his habeas corpus application, it is Friday. And Friday is significant in the police armory. It is the best day to arrest you. The implications are well known. So that you are in custody on the 1st, and by Friday the 3rd, if a step has been taken by a habeas corpus or a serious inquiry has been made, he may charge you. He may formally arrest you and charge you. And clause 15.1 speaks to that. A police officer may arrest without warrant a person whom he has reasonable cause to believe is a gang leader or gang member, or, and I would prefer this language, or a person whom he has reasonable cause to believe he has committed an offense under this act. So that on the Friday the 3rd, the person may be arrested. No charge needs to be brought against such a person at that point because the anti-gang bill does not require a charge, contrary to what the Police Service Act does. And then, if I understand this legislation correctly, thereafter, he may detain you. It appears that the legislation contemplates that there are two concepts. One is arrest and one is detention. If you look at 15.1, clause 15.1, you see the police officer may arrest. If you look at clause 16.1, the police officer may detain you, notwithstanding any law to the contrary. And so, may I say, by way of a sidewind, presumably, we are going to either establish or reinforce detention centers in this country, give them a legal status, and treat people there until such time as the gang warfare has ceased and gangs have disappeared. So, on Friday 3rd, he takes the step to charge you, and he has 48 hours within which to decide on whether there should be an application for further detention. If he makes such an application on Sunday, the 5th, it comes up before the court on Monday the 6th, he's still within his 72 hours. And if the court is so minded, so persuaded, the further detention commences. And perhaps by the 17th of that month, if my mathematics is correct, such a person may be released or may face the court on a charge. So that for the first 17 days of the month, you may be away from home, legitimately kept by the police under this piece of legislation. I am quite certain that the Attorney General will prove me wrong, but nonetheless, there are many citizens outside who may not have thought about it. When a police officer approaches you, are you immediately under arrest? When he invites you to the police station, are you under arrest? Must he charge you right away? Or are you in detention? Now, let me put that differently. Detention reminds me of my school days. Are you detained properly? And if so, until when? When may persons intervene on your behalf to bring an end to this? Clause 16 says the time from which the detention would be deemed to have started retroactively will be the time from which he has arrested you. I have sought to demonstrate that there is some uncertainty in the minds of myself and maybe others as to which comes first, the arrest or the detention, and when does time begin to run. So may I leave that to the better minds who are engaged in this, and to hope that it will eventually resolve itself so that there's some clarity in the minds of others. Because we have already accepted that this legislation will require a 3/5 majority, there will be no need for me to comment on the unconstitutionality of what is proposed. It will resolve itself. I'm now going to move to a matter which may well turn out in committee stage to be easily resolved, but nonetheless I bring it to your attention, Mr. Vice President. I'm referring to clause 15 and the use of the terms reasonable cause to believe and satisfied by evidence on oath. Perhaps I could just read the passages that are of concern to me. In the proposed, may I refer to the amendment proposed by the Attorney General, Mr. Vice President? I'm not sure I can. I may? Thank you. What is proposed reads as follows. A magistrate may issue a warrant to a police officer authorizing the police officer to enter and search a dwelling house where the magistrate is satisfied by evidence on oath that there is reasonable ground for believing that there may be found in the dwelling house a gang leader. I pause there. The police officer comes before the magistrate, provides him with evidence. The magistrate is satisfied that there is in that evidence reasonable ground for believing that someone may be found. What it goes on to say, however, is this. The magistrate may issue the warrant to a police officer to enter and search a dwelling house where the magistrate is satisfied by evidence on oath that a person whom the magistrate has reasonable cause to believe has committed an offense. It is at the very least ambiguous, but it could be worse. Because we've now placed the burden on the magistrate to himself have cause to believe that a person has committed an offense. When in the earlier parts of 15.2, what we really said, and that is the proper approach, it seems to me, in preparing legislation, the magistrate's only function is to look at the evidence before him, make no personal determination about, subjective determination rather, about how he feels about it. He says, on the basis of the evidence you have provided me on oath, I am satisfied that there's ground for believing. The magistrate ought not to be the reservoir, the person who determines whether there is reasonable cause to believe that the offense has been committed. I hope this slight distinction I'm making resonates with the Attorney General so that it can be addressed. Because if he has to be satisfied, the magistrate that is, that there is cause, then is there a higher standard? Is it that firstly he must say, I have seen your evidence on oath, and what is more, I am satisfied that there is reasonable cause to believe that this man has committed an offense? If he has to apply a higher standard, may perhaps Honorable Attorney General may be able to tell us what standard applies to which level of satisfaction the magistrate is required to bring himself. In 15.2 also, there appear to be two offenders. The gang leader is one of them, and the other one is this person whom the magistrate has reasonable cause to believe has committed an offense. For example, that he has harbored a gang leader or paid money to him or sought to prevent someone from leaving the gang, etc. The language is such that it may be better if we simply identified that the magistrate must be satisfied by evidence on oath that there is reasonable ground for believing, one, that there's a gang leader there, or two, some other person, not a gang leader or member, but one who has committed another offense under the Act. I'm taking this rather tortuous approach because I am quite satisfied I will not be here at the committee stage and therefore will not be able to make a contribution, which is my forte, but there will be others. So, Clause 12, may I now invite your attention to Clause 12? merely to ask, may I just remind members what Clause 12 says? It is the one that deals with harboring a gang member. It says a person who harbors a gang leader or a gang member commits an offense and is liable on summary conviction to imprisonment. I thought for a moment that one ought to ask, is there in the mind of the framers of this legislation any consideration for a rehabilitative process for children? Is the child offender likely to find himself in court under this legislation? A person of 16, 17, as the case may be, the ones who are more likely to be attracted to gangs, either for protection or because it looks good. Does this legislation, or this legislation, let me put it differently, or this legislation not endeavor to ensure that children at their tender age, subject to allurements, could be protected by introducing some rehabilitative process, something that prior to the charge being proved or laid or proved against them may turn them in a different direction? I'm sure that there are others here who are better placed to speak to that kind of thing. I'm suspecting that Senator Raffoul was thinking about that, and those others who have suggested that social programs are best. A young man of 15 or 16 who finds himself in his neighborhood crew, gang, lime, whatever may be, hanging out on the street corners, as some parents are permitting children to do these days, may well find that this piece of legislation determines what his future is going to be like. And it would be regrettable if it simply were to be applied across the board without any concern for the fact that this is a child. And he's going to remain a child, according to my understanding of these things, until he is 18, but with a record that may turn against him. We were told that 70% of people or more join gangs for reasons other than economic benefit. They want to belong. And that stage of wanting to belong continues way into the 20s in some cases. You see? So that there's need for us to step back a bit and ask ourselves, can we do something in this legislation, whether by way of a provision or not, that says, but if you are a child, and you may determine whether there could be a new definition of child, so perhaps a fellow of 18 is the horse has bolted, but there may be a point in time where we can intervene, divert the child, and save the child's future. And finally, I promise I would be short, although sometimes time is a runaway horse when it's in my hand, but it is not in this case. Clause 17. Clause 17 reads as follows. It is the one dealing with forfeiture of property. It says, subject to section 2, and my focus will be on 2, where a person is convicted of an offense under this act, the court may order that any property used for or in connection with or obtained as a result of or in connection with the commission of the offense be forfeited to the state. And then 2, before making an order under subsection 1, the court shall give an opportunity to be heard to any person who claims to be the owner of or to have an interest in the property. This is infelicitously drafted. Before making an order under subsection 1, that is for forfeiture, the court shall give an opportunity to be heard to any person who claims to be the owner of or to have an interest in the property. May I suggest that we redirect our attention and place the burden upon the state to satisfy the judge that it has taken steps to alert or to invite members of the public to identify, to express their interest or their ownership in the property. I can't see the court gathering up itself simply to say, well, has everybody who has an interest in this property been given an opportunity to be heard? What answer is he going to get? Yes, my lord. So, but if we place the burden on the state, when they come before the court to determine the question of how the property should be disposed, the obligation would be firstly to establish, and we see it all the time, an article in the newspaper, a publication in the newspaper, the port does it all the time. I have the following miscellany, a list of goods, and it says you have 80 days, 20 days, 24 days, what have you, to come forward and express an interest. Somebody has sought a grant of probate, 2 weeks, Thursdays, caveat, come forward, register a caveat, demonstrate your interest. The likelihood of my relative who has lost jewelry becoming aware that there is someone before the court charged with that property, because the police has held him and found it on him. We have no way of knowing, but we know it is the proceed of crime. And it goes. Or that somebody who has gone onto my land in the country and, I don't know, stored material that contradicts some of first schedule. Maybe I could find one. He has ammunition on it, and I am unaware because I don't go there frequently. I belong to the landed gentry. I may well find that I lose my property because I wasn't reading the newspapers. I haven't joined that bunch of people who don't read the newspapers yet, but it may soon come. And so the judge has simply asked himself, and this is not because the judge is lazy or unconcerned, it's because the only obligation placed on him is to say, has everyone been given an opportunity to be heard? And the police officer glibly says, but of course. We mentioned it in the papers. It was on page 3 of the local newspaper or in the gossip columns or something. And perhaps I could pause there. The state ought to take the burden and the court to satisfy the court that it has taken steps properly to bring to the attention of a potential owner the potentiality for loss of his property. Regrettably, Mr. Vice President, those are all the matters I wish to make an observation on. For the benefit of those who will sit in committee stage, I would merely invite their attention to the following provisions, which could do with some beefing up. In clause 5A, the use of the word admitted. It says where a person has admitted that he's a gang leader or member, that may constitute evidence. I should have liked to ascertain admitted to whom. There was a time I recall when we were doing the anti-gang bill in 2010. He said, a young man who is liming on Independence Square and tells his friends that he's a gang member could find himself in trouble because he's made an admission. But it could not be that is what is intended here, that will be evidence against which you may use against him, that he tells his friends who he wants to think he is, I don't know what's the modern word for it.
A ranker.
A ranker, I don't know, okay. He wants his friend to think that he's what he is not. And he says, yeah, I am in the X gang. You may find that is enough evidence on which a police should arrest him. So, clause 5A, when you come to committee stage, perhaps you may want to do something more with the use of the word admitted. Clause 15, I have alluded to that already. In 15.1, I think we should say instead, where it says, or who he has reasonable cause to believe has committed an offense, we should use the tried and trusted clause, or a person whom he has reasonable cause to believe. And there is one more observation, if you would permit me. Once again, because I may not be here at committee stage, I should like that to be taken into account. It's to be found in clause 16. It refers back to the distinction in my head between arrest and detain. And it's where it says, notwithstanding any law to the contrary, a police officer may, without warrant, detain. I should want it to be considered whether there ought not to be an arrest before detention, or if it is that the framers of this legislation wish to keep those two events separate for reasons best known to themselves, make it clear that they are separate steps that a police officer may take. Mr. Vice President, I thank you very much for the opportunity to have contributed to this.
Honourable members, at this point we will take the tea break. So this House will now stand suspended until 4:45.
Want to see your parliamentarians in action but not close to a television? No problem. Log on to our YouTube channel, ParlView. Go to www.youtube.com/ParlView using your laptop, tablet, or smartphone. It's that easy to keep up with all the sittings of the House of Representatives and the Senate, and live Joint Select Committee meetings and even media briefings. Don't forget to click the subscribe button to receive a notification when we are streaming live events. So visit our YouTube channel, ParlView, to keep current with all our parliamentary happenings.
Follow the Parliament of Trinidad and Tobago on Twitter. Our call sign is @TTParliament.